Hello student, I'm Madam Chiti Soba with you today. Today, I'm going to discuss how to answer problematic and essay questions during final examination or your test or your final assessment. Okay, so what I'm going to discuss with you today as to how the method of answering problematic question using ILAC and how to answer essay questions. This is a guideline for my student. So meaning this is a guideline for law students who take up law and who attended class with me. As for other students who did not attend class with me and you are from other classes whereby your lecturers are other lecturers, please follow the guideline which is being given by your own lecturer. Okay. So what is actually ILAC? ILAC, I stands for issue. So what is actually issue? Issue is actually the problem, the law problem you whereby you can find in this situation given. Ini adalah permasalahan undang-undang. What is the problem with regard to certain issue of law? So this we need to identify this here, this first. If there is no problem, of course, then we are not going to use the statute and use this case law to settle the said problem. So that's why we need to find the problem first, the issue first. And what's actually the law? The law, this is the statute, the ordinance, the enactment, okay, and other statutes which we are going to use to back up our argument. And what are the cases involved which we can relate to this said issue? So the application, this is the argument. So meaning we are going to apply the law, we are going to apply the statute which we have identified to resolve the said problem. And lastly is C, the conclusion. The conclusion is we are going to wrap up our discussion. This is where our advice to the parties, it will appear here. So meaning what actually our decision pertaining to this problem. So, okay, students. So let us go on with the use of ILAC in these questions. This is a questions, final assessment questions during June 2020. So let's have a look at these questions. On the 10th of April 2020, Azra wrote to Azim proposing to sell her apartment in Kelang Damai at a price of 230,000 ringgit. Azim accepted the proposal through a registered letter posted on 13th of April 2020. Since there was no reply from Azim for about a month, Azra sold the said apartment to Salim on 5th of May 2020. On 6th of May 2020, Azra received Azim's acceptance via a registered letter to purchase the said apartment. Azim intends to take legal action against Azra for knowing that the apartment had been sold to Salim. Advance Salim. These questions carry 30 marks. So how the mark is being given, I've put by the side there how many marks it carries for each and every issues and law you have already discussed. So now let us have a look at what are the issue and what are the law involved in this matter. So I have identified 3 issues here. The first one, where the silence is deemed as a good acceptance. And to discuss this issue, I am going to use Section 7B of the Contracts Act, and the case law to back me up is the Pell House versus Binley. The second issue is that the acceptance can be done through post, and the statute I'm going to use is Section 4, Subsection 2 Contracts Act, and the case I'm going to rely on is Ignatius versus Bell. The third issue is whether there is revocation of offer. The statute I'm going to use is Section 5, Subsection 1, and Section 6 of the Contracts Act. And the case which I'm going to rely at is Ramsgate Victoria Hotel versus Montefiore. So if you realize this, student, I did not elaborate on the issue, and also I did not elaborate on the law at this level. At this level, what I did is that I only list down the issue and also the law which I have identified. So, however, for other lecturers, some lecturers, they want the student to elaborate it further. So that's why I said, if you are not from my class, meaning the lecturer who guides you with other lecturers, you need to follow their guideline. For my student, this is how I want my student to do it. You just need to identify the issue and law. That's all. No elaboration. Because to me, once you identify the issue and law, you list it down. This actually will act as a GPS so that you won't go astray. So we are going to discuss only on this argument alone. Okay, so that's why we need to identify the issue and law. And if you can see the ones in red, and I have written the word not 1, 2, 3, 4, 5. What this means? I mean here, this is not the issue here. So why I say this is not the issue? Whether there is an offer, not an issue here. Whether the offer made to a particular person is not an issue here. This is because, so this is clear. Something which is clear. So meaning, this is very clear that this is already an offer made by Azra to Azim. So if it's very clear, it's not being disputed, there is no question pertaining to this problem, that it cannot become an issue. An issue is something which we can dispute. Okay, which we can question. Sesuatu yang kita boleh persoalkan. Itu barulah kita katakan satu issue. Kalau tidak ada persoalan, itu bukanlah satu issue. Meaning, if this is very clear, then it will not become an issue. It's very clear that this offer is being made to Azim. Okay, so, and it's also very clear that the said offer had already been communicated because Azim is fully aware about the said offer, and because of that, he accepted the said offer through a registered letter. Okay, because this is very clear, then we cannot take it as an issue here. So, what about whether there is a contract and whether Azim can sue Azra? So, this is what we are going to discuss at the conclusion part. And furthermore, when we say something is an issue, okay, you need to narrow down your issue. It cannot be very wide. It's just like when you go for a battle, okay? You need to identify the location of your enemy. You cannot just shoot everywhere, okay? If you say your enemy is at location B, which part of location B is actually your enemy? So that you can win the war, okay? So if you are a doctor also, and you have a patient with you, you need to identify, you know that the patient is sick. Okay, what kind of sickness is this? Is this a cancer? If this is a cancer, what kind of cancer? What stage actually is this cancer? What is the prescription of the state medicine which need to be taken by the patient? Okay, so that's why we need to narrow down our discussion. Okay, so I'm going to discuss this problem. This now, I have already identified the issue. I had already identified the law. And so now I'm going to apply. So I don't want students to elaborate. Why? If students elaborate at the issue and law level, then when they did the application stage, they are going to repeat the same thing again. This will be a waste of time. Okay? So at this application stage, this is where you need to make use of the statute and make use of the cases which you have identified. So from here, we know that whether you understood what is being taught to you, you know how to apply it. You know, if you have an ingredient, let's say to bake a cake, okay, you know this is ingredient. However, if you do not know how to use it, then your cake will not be tasty. So it's the same thing here. You had already identified the issue. You had already identified the law. You elaborate on the statute. You elaborate on the cases. However, how are you going to use it? This is where I'm going to test you. Okay? So that's why I said you need to show me how you apply it. So let us have a look as how I do it here. So, issue number one. So here, in the above problem, Azim did not inform Azra that he accepted the said offer. According to section 7, subsection B, an acceptance must be expressed, and any absence of response will not be considered as a good acceptance. This is clearly illustrated by the case of that house versus Binley, whereby an uncle wrote to his nephew that he is interested in buying the horse belonging to the nephew. However, this was not conveyed to the auctioneer, who had sold off all the property of the nephew, including the said horse. In fact, the nephew had never responded to the offer made by his uncle. It was held that there did not exist any acceptance here. Reflecting to the situation of Azra and Azim, can it be considered that is silent on the part of Azim in not responding to the offer made by Azra? Since the law is very clear on this, that all acceptance must be communicated. So, meaning here, student, I have made use of section 7B and also the case of Feldhaus versus Minley, whereby I have asked here, can we say that there is a silence on the part of Azim since he did not convey his acceptance to Azra? Okay? However, I did not conclude yet. Why? Because my conclusion, my advice will be argued in the conclusion stage, at the conclusion stage. Okay, so now let us go on with issue number 2. Of course, when I discuss issue number 2, it needs to relate to number 1. Why? Because the discussion needs to go on smoothly. Okay? So, however, here I'm discussing, however, we have to bear in mind that communication of acceptance have a few exceptions. One of it is provided under section 4, subsection 2 of the Contracts Act, whereby it covers acceptance which is being done through oath. In the above problem, Azim accepted the said offer through a registered letter posted on 13th of April 2020. It is just that it took nearly 1 month for the said letter to reach Azra, which is on the 6th of May 2020. The question here is when actually the date of contract. According to section 4, subsection 2, the acceptance is deemed communicated and conveyed to Azra when it is put in the course of transmission to him, which is on the 13th of April 2020. Because at that time, it is already out of the power of Azim to control the said acceptance letter. Why? Because he had already posted it. Okay? So, we can say here that the contract is actually binding on Azra on the 13th of April 2020. This situation is similar to the case of Ignatius versus Bell, whereby there is an offer made to sell a piece of property until 20th of August. The acceptance letter was posted within the time frame, which is 16th of August. However, it was received by the offeror on the 25th of August. Taking into account the proviso of section 4, subsection 2, the court held that the acceptance was completed and binding on the offeror on the day the letter was posted. By taking into account of section 4, subsection 2, and the case of Ignatius versus Bell, silence might not be a good defense for Azra. Okay? So, for issue number 1, issue number 2, I have by the side there, in maroon color, I have put there. So how many marks actually it carries for you for this discussion? 8 marks. So meaning 4 marks is for the statute which you have discussed, and another 4 marks is for the case law which you have discussed. So altogether actually is 8 marks. So meaning if you miss one of the statute or you miss the case law, you are going to lost mark. Okay? So you need to be clear about this, about the marks. Okay? So this is how mark is being given for each this question. Okay? Okay? So, student, I did not conclude yet, right? I did not conclude yet. My advice is not here yet. Okay? As I told you earlier, my advice conclusion is at the end of the discussion. Okay, student. Now let us continue with issue number 3. So under issue number 3, this is how I'm going to discuss it. Whether Azra can claim that there is a revocation of offer since Azim did not accept his offer immediately. If we go through section 5, subsection 1, whereby it provides that revocation can be done at any time before the communication of its acceptance is complete against proposal. Through discussion number 2 above, we argued that the communication was complete at the time when the acceptance letter was posted on the 13th of April 2020. So I'm relating to our answer under number 2, okay, under issue number 2. So that's why I said we need to relate each and every issue so that the discussion will go on smoothly. So thereby, I'm continuing now, student. Thereby, if Azra wanted to revoke his offer, he have to do it before 13th of April 2020. Nowhere was mentioned when did Azra revoke his offer. Whether Azra can use section 6, subsection B of the Contracts Act by saying that the offer is revoked automatically due to lapse of time or lapse of reasonable time. Since Azra did not specify the time frame for acceptance to be done, can he say 3 days is too long and unreasonable? Taking into account the case of Ramsgate Victoria Hotel versus Montefiore, whereby the offer to buy share was made in June and the acceptance was done in November. And it was held that the offer had already lapsed, though the offeror did not give time frame since this involved share. In the case of Azra, can we say that 2 days will affect the market price of land when comparing with the case of Ramsgate Hotel, when the court held 5 months is held too long and therefore the offer had lapsed? Okay, I finished with applying the statute and the cases to all the 3 issues. So now I'm going to go on with the conclusion. So I'm going to conclude each and every issue using all the statute and all the cases I have discussed earlier. So my advice will come here. So my conclusion also will come here, will appear here. So I'm going to justify each and every one of my advice and my conclusion using the statute and case law which I have highlighted earlier. So issue number 1 is now, by considering section 7, subsection B, and the case of Feldhouse versus Binley, we could conclude that actually Azim did express his acceptance. It is just that he did it through post, since Azra did not prescribe or insist the method of acceptance. And because of that, we could not say that he did not respond at all, and therefore the case of Feldhouse could not be applied to his situation. What I'm saying here, student? I said, and what I'm trying to say here, student, Azra cannot say silence is not good acceptance. So that's why I said Feldhouse could not be applied. Okay. So issue number 2. Since Azim have chosen to choose acceptance through post, therefore, section 4, subsection 2 will come into effect, and therefore the date of contract and also the date of communication of acceptance is on the date he posted the letter, which is 13th of April 2020, and not the date when the letter reached Azra, which is after he had sold off the property to Salim. We can conclude here that the case of Ignatius versus Bell will be applicable and Azim is entitled to sue Azra for his remedies. And issue number 3, can or not Azra claim that he had revoked the offer when he had never communicated his revocation of offer at all to Azim according to section 6, subsection A? Or alternatively, can he resort to section 6, subsection B, which is lapse of time, taking into account the case of Ramsgate Hotel, which is nearly 5 months before the acceptor start the offer, while Azim took only 3 days. We may advise that it is not practical for Azra to use this defense, and Azim can claim his right for breach of contract by Azra. Okay, student, I have completed with my conclusion. If you go through my answer, So maybe students, you said that there are other issues. What are the remedies available if this is the situation, if this is my advice, and what are the remedies available to us, and why I did not discuss this here? This is because for your purposes, you need only to cover offer acceptance, considerations, capacity, and intention. Okay? Remedies, discharge of contract. This is not actually covered for these purposes. Okay? So that's why I cover only these for element of contract. Okay. Okay, student. So now let us have a look as to how we are going to answer essay questions. So essay questions is more straightforward. So we need to divide it into three parts: introduction, content, and also conclusion. So if you are aware just now, when we are discussing with regards to the problematic questions, I put numbers. So every discussion, there are numbers. Why actually I put numbers? Every paragraph, there are numbers. This is paragraph 1, number 1, paragraph 2, number 2, paragraph 3, number 3, right? So this is to make things much more easier. So we can identify things easier. We can look at the discussion more easier. We know that this relates to where. Okay, so that's why you need to do this. You list it down according to numbers, so that it will be easier for you to identify and easier for me as the lecturer when marking, for me also to identify it. Okay, and it's more proper if you highlight the statute which you use, the law which you have used, and also the case law which you use. So that's why I'm highlighting that too just now. Okay? So student, with regards to essay questions is much more straightforward. So you need to divide into three parts on it: the introduction stage, the content, and also the conclusion. At the introduction stage, this is the stage whereby you are going to introduce the subject matter which you will be discussing. You need the introduction part. Right? We don't have this introduction part in the problematic questions. And then only we go on to the content. Okay? So the content will carry more marks. Okay? So the content, you need to identify the subject matter and you need to divide the subject matter accordingly so that you can put numbering also. So you know actually how much you are going to discuss pertaining to this content. And lastly, of course, the conclusion, you are going to wrap up your discussion. So let us look at this question. This is essay questions, also June 2020. The question is with regards to consideration, and it carries 10 marks here. It says, they ask here, the consideration need not be adequate, but must be sufficient. Briefly discuss the validity of this statement. Okay, so meaning you need to justify this statement. So how to answer it? As I told you just now, you need to introduce the subject matter first. So here, at the introduction stage, what I did, I introduced considerations. How many types of consideration there? So I've discussed these types of considerations. It's quite lengthy here. Yeah. However, you can simplify it because it only carries one mark. Then only we go on to the content. The contents will carry more marks. So I have divided the contents into 4 parts. You can realize here 4 parts. Okay, I have divided into 4 parts. Okay, and each part, I know that actually because 4 parts is 10 marks. So each part will actually give you 2 marks, and conclusion also will give you only one mark. So let us look at the content. So just now I have divided it into 4 parts. So number 1, I'm going to discuss on the requirement for consideration. Okay, whether all contracts need to have consideration. So I'm using section 26 and the case of Tanso same here. Okay, because under section 26 it says that if the agreement have no consideration, has no value, that will become void. Okay, and I said that's why in the case of Tanso same, the court held actually the agreement is void because there is no consideration being provided for this agreement. So it carries 2 marks. So we know that for the statute highlighted, 1 mark. For the case is 1 mark, 2 marks. Okay. And then content number 2, I'm going to discuss with regards to adequacy of consideration. 2 marks here. Yeah. So I highlighted here the explanation of section 2 to section 26 because this is the section which says that consent is much more important compared to adequacy of considerations. Okay, whereby under this section it indicates that if there is consent, then though the consideration is not adequate, the consideration will still be valid. Okay, that I go on with content number 3. So here I highlighted the case of Pang Sui Kim. So in Pang Sui Kim, whereby the consideration for sale and purchase of land is 500 ringgit. So though the amount is very little, okay, it's not adequate to the value of the land, to the market price of the land. However, the court have held in this case, since there is consent on the part of both parties at the time when they make the contract, because of that, the consideration is also valid. And under number 4, I've discussed the case of purposing, because in the case of purposing also, the consideration is not at par, is not the same as the amount of contract. Actually, the debt owns is 8,000 ringgit. However, the son is willing to pay only half of the said debt. However, the court held this is valid consideration. Why? Because both parties consented to it at the time of the said agreement. Okay. So after discussing the content, so now I'm concluding. I'm concluding with regards to all my discussion just now. So in the conclusion here, I said it's very clear from section 26 that, okay, so in the contract, the consideration is a requirement. However, as long as there is free consent, then though it's not adequate, the said consideration will still be valid. Okay. So as a proof, I said here, we have a look at the case of Pang Sui Kim and also the case of Kerpasing. Okay, whereby under both cases, the consideration is not adequate and still the court has held that actually the contract is a valid contract. So, okay, students, thank you for listening to my discussion today. So I hope this discussion did assist you in answering your exam question, test question, or your assessment. Thank you, students. Bye-bye.